A very warm welcome. Good afternoon to all our viewers, our students, wherever you are. Uh, we at the Center for Constitutional Law and Policy, Paru Institute of Law, Faculty of Law, Paru University, have been carrying out a number of sessions on a various subject matters. Today, we have envisaged to carry out a session on media law, whereby a kind of a niche area within media law, that is decency and morality of media art, a constitutional perspective. So really interesting topic we have for today, and the resource person lined up for today is again very apt for that particular topic. We have got Ms. Shreya Deb. She is a legal consultant at Jungli Pictures Limited, a leading film production company based in Mumbai. She earned a BA LLB degree, honors in mass communication and constitutional law from Alliance University, and further earned an LLM in media law, policy, and practice from the University of East Anglia, UK. She was awarded International Office of Excellence Scholarship for the same. Shreya brings along a diverse work experiences from Law Crafts, Mehta and Mehta Law Firm, A&M Global, and Jungli Pictures Limited. She has had the experience of leading the full project cycle for Enactus UK in the position of Vice Project Leader, and she has served as a member of the advisory board of Legal Fox's Law Times Journal, and currently serving as Vice President of Daman and Diu, Cyber Security Council at Women's Indian Chamber of Commerce and Industry. She has also had a very spirited interest as far as writing is concerned, and has several papers published in local, national, as well as internationally circulated journals and blogs against her name. She is also a certified mentor at Expert Rounds. So, Shreya, we are really glad to have you with us here at the Center for Constitutional Law and Policy, Paru Institute of Law. A warm welcome to you.
Thank you for your warm welcome. I also would like to extend my gratefulness to Paro University for inviting me here to this platform. Well, so I'll be sharing a slide with all of you for better understanding and to keep the session as interesting as possible. Well, so the topic decency and morality of media art, a constitutional perspective. This aspect is very blurred when we talk about decency and morality. As such, nobody can define as to what is decency, what is morality. So, to commence this session towards a wider assessment, one should understand what media art is and what needs to be dealt with while thinking about a thorough analysis of decency and morality under the Indian Constitution. So, media art, it can be described as a form of art, a liberal space used by journalists, activists, artists, or academicians to express their views, their opinions. It's basically exercising your freedom of speech and expression in the manner you would like to. And it extends not only to paintings, films, books, theatrical works, advertisements, cartoons, but also to music videos, stand-up comedians, advertisements, televisions, etc. Basically, whatever the human impulses creates. So, sounding like that, it sounds more like a creative freedom, isn't it? So, as we know, that the freedom of speech and expression, which is a fundamental right guaranteed under the Indian Constitution, this implies the freedom of speech and expression not only extends only till freedom of press, but also to artistic freedom and creative freedom. Let's reiterate the facets of constitutional provisions which are provided. The preamble to the Constitution provides us liberty of thought, expression, and belief. And to make it more specific, we do have Article 19, Clause 1, Subclause A, which provides each citizens of India the right to speak, freedom of speech and expression. However, this freedom of speech and expression do not mention what kind of expression it is or the scope of expression. And to clear that dilemma, that question, Mr. Dr. Ambedkar, the chairman of the drafting committee, stated that no special mention as to the freedom of speech and expression was required, as the press or an individual or any citizen of this country were the same as far as the freedom of press was concerned. And the framers of the constitutions kept that in mind while framing this constitution, that everyone's creative or artistic freedoms are considered while we talk about freedom of speech and expression. However, there are certain reasonable restrictions which are laid down so as to carry out the special duties and responsibilities in line or in compliance with the law. Therefore, it is not an absolute right. It is subjected to certain limitations. And since the press derives its freedom from Article 19, Clause 1, Subclause A, the limitations set out for freedom of speech and expression applies to the same token. So here we are with Article 19, Clause 2. So the main reasonable restrictions are sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. However, we will be sticking to decency and morality, and we must know that these all reasonable restrictions were laid down in order to safeguard public interest. So, what exactly is decency and morality? Do you know what is decency? Can you define that? No, right? It's very difficult because it's a very decency and morality, they're very vague and elastic notions that evolve with time, social change, and very vastly from one culture to another culture. What may be morally acceptable to one section of the society may be unacceptable or outrageous for another society. For example, consider polygamy. Polygamy may be accepted by certain sections of the society. However, it is not the same for every society. So, similarly, coming to freedom of speech and expression, the way to express something or to say something must be a decent one. It should not affect the morality of the society adversely. And in order to do so, our constitution has taken care of this. So, therefore, he inserted the framers of the constitution inserted the terms such as decency and morality so as to keep in view that decency and morality are maintained while freedom of speech and expressions are carried out. So we do have certain laws which are framed in order to maintain decency and morality. These statutes are made with the view of the parent law, that is the Indian Constitution. The first one is Indian Penal Code. So section 292 to 294 of this provision provide instances of restrictions on the freedom of speech and expression in the interest of decency and morality. These sections prohibit the sale or distribution or exhibition of immoral or obscene words, etc., in public places. However, we must know that there is no such fixed standard that is laid down till now as to what constitutes morality or decency. The standard of morality has been varying from time to time and from place to place. And to second that thought, I would like to mention the Supreme Court's order in Chandrakant Kalyandas versus State of Maharashtra, where the Supreme Court observed that such notions vary from one country to country depending on the standards of morals of contemporary standards. And speaking about India, even though it's the same country, but it's a very culturally diverse country. So within India, even there are widely varying standards of moral acceptability. For example, something may be unacceptable in my place, however, it may be acceptable in the place of Gujarat, and vice versa. And this cultural diversity we often find when you consider big cities like Delhi, Mumbai, or Bangalore as compared to the small rural areas. So it's though it comes within the same country, this culturally diverse morality standards. This makes it extremely difficult to define or straitjacket this kind of concepts. So coming to the next statute, that is the Cinematograph Act of 1952. This basically prohibits the certification of a film by the censor board for public exhibition in case the film or any part of the film is against the interest of morality and decency. Now, giving you a very good example, Urta Punjab. This movie had to go through 89 cuts in their movie just because there were cuss words used, there were certain scenes which went against the notion of morality and decency. Another good example would be the movie Lipstick Under My Burqa. This movie is based upon the sexual awakening of four women who are based in the conservative place of Bhopal. So the CPFC that time stated that it was a taboo, and because this movie comes more like a lady oriented movie and their fantasy over their life on sexual pleasures, this needs to be banned. So the aggrieved party, the producers of the movie, went to FCAT, that is Film Certification Appellate Tribunal. So they moved to FCAT, and there the FCAT compelled CBFC to provide a certification for this movie. And finally, they were granted a A certificate. And the irony here is this movie has been awarded as the best movie for gender equality. Well, moving on to the next statute, that is the Dramatic Performances Act. Similarly, just like Cinematograph Act was performing its function on films, dramatic performances does not allow any kinds of obscenity in public dramatic performances. And then let's move to Indecent Representation of Women Act. So it basically this provision prohibits the indecent representation of women through any media forms. But what exactly is indecent representation of women? The term itself says that you cannot represent a woman indecently. It means depicting a woman or the figure of a woman, her form or body or any part of her body in such a way just to have the effect of indecency, derogatory, deintegrating a woman, and which is likely to corrupt or injure the public morality. So that is indecent representation. So basically, indecent representation of women is prohibited. Next, coming to the IT Act, similarly, just like Dramatic Performances Cinematograph Act, the IT Act plays its role in electronic form. So any obscene material in electronic form comes under the IT Act of 2000. Next is Cable Television Networks Regulation Act of 1995. It prohibits the telecasting of programs on cable television which offends decency and morality. So this effectively means that any form of adult movie which or a film which has been certified A, uh, they cannot be telecasted by cable operators. So you must have noticed that you cannot watch an adult movie on the television, and this is the reason behind it, the Cable Television Networks Regulation Act. Now, what is obscene and indecent media forms? What exactly is obscenity, and is obscenity and indecency the same? You must have noticed that in the context of decency and morality, the term obscenity is often used. And why is it so? Is it because indecency and obscenity, they are synonymous? Is it? Not really. So what is it? Though they sound identical, but are they identical? So this is what obscenity and indecency means. Obscenity is defined as offensive to modesty or decency, something that is lewd, filthy, and repulsive. And indecency is a concept that is much more wider than obscenity. So you can say that indecency means something which is non-compliance with the moral standards or the norms set out by the society. However, obscenity is something filthy. So something which is obscene is definitely indecent, but something which is indecent may not be obscene that way. Something, because that is something, indecency only based upon the moral standards. However, obscenity is not based upon moral standards. So what is obscene is necessarily indecent, but what is indecent may not always be obscene. Now, moving on to this vague concepts of sex, nudity in media art, and is it the same as obscene media form? If not, then what? So, we often tend to get confused between sex or nudity, sexual explicitness in any kind of media art. Say a painting which has sexual explicitness, we tend to think it as, oh, this is an obscene media form. Or think about you're watching a movie and there's some sexual explicitness in the film. So does that mean that it is obscene? So this discussion, after this discussion, you will understand whether or not it's the same or not. So here I would be speaking about three different cases to make this concept more clear. The first one being Ranjit the Udeshi versus State of Maharashtra. So this case came out of because of a book that is Lady Chatterley's Lover. So the publication of this book was in question. Well, observing this case, the Supreme Court held that sex and nudity in art and literature cannot be regarded as an evidence of obscenity without something else. So, in case if you just decide that because there is sex, this is obscene, that is not the case. That's what the Supreme Court meant. And going by this rigid test of treating sex as the minimum ingredient for constituting obscenity, then hardly any artist or activist or any academicians will escape the tough definition of uh, obscenity. So half the bookshop would close and the other half would be dealing with nothing but moral and religious books. And therefore, sex and nudity themselves do not constitute obscenity. This was what was held in Ranjit Deodeshi versus State of Maharashtra. In the next case, that is Bobby Art International versus Om Pal Singh. In this case, the main contention was drawing the distinction between nudity and obscenity. The petition was filed by a member of the Gujjar community seeking to restrain the exhibition of the film Bandit Queen on the ground that the depiction in the film was obscene and a slur on the womanhood of India. And there were some rape scenes which was also depicted in the movie, and the petitioners held that the rape scene in the film was suggestive of the moral depravity of the Gujjar community. In response to the petitioners' contention, the Supreme Court said that the scene of frontal nudity was definitely indecent when you speak about Article 19, Clause 2, and even under Section 5B of the Cinematograph Act. However, the object of showing the scene of frontal nudity of the humiliated rape victim was not to arouse sexual feelings but revulsions for the perpetrators. So here, the Supreme Court made a difference between nudity and obscenity in a manner by looking into the intention of the filmmakers, which was beyond sexual purpose. Now, coming to the third case, that is K. Abbas versus Union of India. In this case, the Supreme Court observed that sex and obscenity are not always synonymous and that it was wrong to classify sex as essentially obscene or even indecent or immoral. So, concluding this part, we would understand that sex and nudity is not necessarily obscene. There are various other factors which needs to be considered while determining whether or not a sex or nudity in media art forms obscene material or not. Next, coming to obscenity and pornography. So though these terms are often been confused, like some people think that, oh, pornography is obscene. Yes, it is. But how obscene? Is it the same? So though it is identical, however, we would need to understand that pornography denotes writings, pictures, or videos, etc., which are intended to arouse sexual desire. However, that's not the purpose of obscenity. Obscenity may include publications which are not intended to arouse sexual feelings but have the tendency. So, this is the thin line of difference between pornography and obscenity in any media forms. So, next time you come across a movie which has obscene materials, you would know whether or not it constitutes pornography or obscenity. The thin line is the intention. Pornography's intention is to arouse sexual feeling, while obscenity's purpose is just to have the tendency while not being the main contention. While both offend public decency and morals, pornography is obscenity in the most aggravated form. Now, we'll move to how the courts determine whether a media art is obscene or not. So, here, before I discuss this topic, Uh, let's reiterate the Article 19, Clause 2. What does it say? Reasonable restrictions to media freedom, isn't it? So, what is reasonable here? The term reasonable in the provision has empowered the citizens or any film producers, authors, or any artist to turn to the courts for judicial review, because going by the provisions of the law, like for example in the previous case, in the Bandit Quinn case, though it was contended that it is indecent or and immoral under Article 19 Clause 2 and Section 5B of the Cinematograph Act, however the court contended that the purpose, the intention of the filmmaker was something else and allowed the movie. So how do the courts determine there? And this rights of the artist, the creative freedom, the artistic freedom is upheld only by looking into the reasonable restrictions. The term reasonable has a huge significance to play here. And the Supreme Court recognized that there cannot be any uniform test for obscenity, and that each case has to be judged on its own facts. The court has, through its various judgments, laid down various parameters to be followed in judging whether a particular publication or a media form is obscene or not. And the parameters are the Heckling test, the likely audience test, literary merit, and preponderating social purpose, the aversion defense, contemporary or national standards, judging the work as a whole, opinion of literary or artistic experts, and test of the ordinary man. So I'll be discussing one by one each of this. So first, let's move on to the Heckling's test. What does the Heckling's test say? It is based upon the effect of media art or any kind of publication on the most vulnerable members of a society, whether or not they're likely to read it. So, for example, a movie, considering the movie Lipstick Under the Burqa, Lipstick Under My Burqa. So, in this movie, it's an adult film. This could have been banned if going by Heckling's test, because then they would have said that we are seeing the impact of this movie on the most vulnerable members of the society, that is children. So they are probably never going to watch that until unless they don't become adult. So this is where this is very controversial test, Heckling's test. And going by this test, a book, The Well of Loneliness, this book was banned by the England court. This test was initially started in England, and then later the Indian courts have adopted Heckling's test. So this is about the year 1928. The Well of Loneliness, the book was banned by the England jury. And the reason behind that is the book had scene of the book basically narrated about two women sleeping together, and the England jury held that that would arouse thought of a most impure character and glorify a horrible tendency, and that's why the book was banned. But in India, this test has been adopted. And what the Supreme Court says behind the reasoning of this Heckling's test is that this test cannot be discarded on the ground that only it looks at the vulnerable members of the society, but it should also be considered in relation to a obscene material or a obscene media form, to look into the potentiality of the impact object to deprave and corrupt by immoral influences. So here the purpose is also to understand how the vulnerable society is going to react, even though we are just taking it as a consideration and not making it a main contention. So this is the purpose of Heckling's test. Now, moving to the next stage, that is the likely audience test. Here, the most vulnerable person, that is the Heckling's test, has been replaced by the likely audience test. The likely audience test, the term itself says likely audience. So, what must be considered is the impact on those who could reasonably expected to gain access to the publication. The test must be based on the target audience and not the person whose hands the publication or any media form might not even come into. So, while conducting the likely audience test, the judge must place himself in the position of a viewer and audience, and try to appreciate what kind of possible influence the media form is likely to have in the minds of the audience. So, for example, if there's a book which is meant for children, the judge has to sit and think like a children. Okay, this is how the book is going to make its impact. And this is what the likely audience test says. Next is literary merit and preponderating social purpose. So when, and in most cases, art and obscenity are often mixed, and in such cases what must be seen is whether the artistic, literary, or the social merit of the work outweighs the obscene element or not. So for example, take any kind of case such as Mardani, that has sexual explicitness in its content. However, that was meant to understand people the concept of rape, how bad the crime can be, the evil in the society. So its purpose definitely outweighs the obscene content in it. And this is what was also done in the case of Lady Chatterley's lover. And here I'm speaking about Ranjit the Udeshi's case. So in this case, this book was banned because the court understood that the book had no social gain for the public, which could overshadow the obscene element. And this is why the book was banned. Next, moving to the aversion defense. Nudity and sexual explicitness do not by themselves constitute obscenity. Authors and filmmakers sometimes depict nudity not to arouse sexual desire, but on the contrary, to arouse horror and revulsion in the audience against the social evil being depicted. This is understood as the aversion defense. So, we are using here sexual explicitness for a totally different reason. And the best example for this would be the Bandit Queen case, where the petitioner challenged the scene of frontal nudity where Fulan Devi, a rape victim, who later became India's one of the most celebrated and dreaded dacoits, was paraded naked before the village after days of being gang raped by members of the Gujjar community. So, taking into consideration this case, The Supreme Court held that the object of the scene of the frontal nudity was not to arouse sexual desires but sympathy for the victim and disgust for the perpetrators. The rape scene also explains why Fulandevi became what she did. So, without showing that part of the story, it would have been very difficult for the filmmakers to convey the message to the audience. And as we know, film is one of the strongest form of mass communication, and rape and sex are not being glorified in this film. Quite the contrary, it shows what a terrible and terrifying effect rape and lust can have upon the victim. It focuses on the trauma and the emotional turmoil of the victim to evoke sympathy for her and disgust for the rapist. So, this is what is aversion defense. The purpose is totally different. In another such case, this is not about a film but a book, a Bengali novel titled Prajapati. So, this book was challenged before the Supreme Court on the grounds of obscenity. So, even then, the Supreme Court upheld the book, saying that the author's intention was to expose certain ills in the society. And to do so, he used his own techniques, own art, skills, and choice of word to that extent. So, how he is able to reach the author. So, here we are seeing how the Supreme Court has upheld the artistic freedom to bring out a social evil. The court found that the use of slang or unconventional words, the emphasis on sex and description of female bodies and narrations couched in vulgar language did not themselves make the novel obscene. The purpose of the novel was much more than that. So, this is what aversion defense means. Next is contemporary and national standards. So, while we are judging a particular work as to whether it's obscene or not, the first regard must be given to the contemporary morals and national standards of a place. So, for example, certain publications may be very okayish for a Western country, but not okayish for India. So, if you use Netflix, you would understand there are certain kind of series which do not have cuts, but the same when projected in India is given with lot of cuts. Why is it so? This is because of the contemporary and national standards of a society, and which is definitely to be regarded. Well, we could also consider the contemporary and national standards for the case of Lady Chatterley's Lover, which I just spoke about, the book which was banned because the Supreme Court thought that there was no social gain which could overshadow the obscene material, the element present in the book. However, the same book was allowed in England by the jury because the publishers found that the publication did not fall on the obscenity test. So perhaps the community morals and standards played a part in the Indian Supreme Court taking a different view from the England jury. The test has somewhat become outdated in this context of the internet era, because today we see a lot of pirated movies, and also everything is available in just one click of mouse. But however, this is one important test which needs to be considered. Next, moving to judging the work as a whole. Now, to explain this, just consider you are watching a movie and all of a sudden there's some kind of obscene content, and that's when your mom walks in the room. How would your mom react to it? Hey, what are you watching? Is this what you're supposed to be watching? But in case if your mom was sitting with you while the movie was played from the start to the end, she would have understand that, this movie is not just obscene. There is an entire story, and that was just a part to depict certain story, a plot, to make it to bring the storyline out. So that was the purpose. So likewise, this is what is considered even by the Supreme Courts, that we cannot just look at this obscene element, we need to judge the work as a whole. And to do this, even certain guidelines are laid down under the Cinematograph Act, which says that the Board of Film Certification should ensure that any kind of film is judged in its entirety from the point of view of the overall impact and not just a part. Now, moving on to the next one, that is opinion of literary or artistic experts. So here we um, sometimes do not understand certain paintings, the purpose of paintings, or think a a publication is being objected and it comes to the Supreme Court. Well, it's in some other languages. How would the Supreme Court determine whether or not to ban that book or not? So, in order to do so, what the Supreme Court does is that they can appoint some literary or artistic experts to determine whether or not it falls under the criteria of obscenity, indecency, or immoral. However, the verdict as to whether the book or article or any form of media considered to be obscene or immoral must be judged by the courts and ultimately by the Supreme Court. The literary or experts can only give their opinion. The final decision rests upon the courts. The last one is the test of the ordinary man. The test for judging a work should be that of an ordinary man of common sense and prudence, and not out of the ordinary or hypersensitive man. Now, if it's a hypersensitive man, for every single issue, he would make it a big dilemma. Oh my God, this is obscene, this cannot be allowed. So, the point here is the court must look into the point from an ordinary man. Well, coming to the concluding part, first I'll be speaking about the highlights. So, the next time you watch a movie for your own thing, you would understand where to draw the line between what is indecency, what is obscenity, because there's, of course, a difference between indecency, and obscenity, as we just understood. Everything what is obscene is definitely indecent, but what is indecent necessarily be obscene. So this is one thing. Another thing is you would learn how to differentiate between what exactly is the difference between sex, nudity, and obscenity, pornography, and obscenity. These are very blurred lines of differences, and any person have to consider several factors while making a differentiation between these two. And we must see that how the history has shown that attempts to suppress the publications on grounds such as indecency or morality have often yielded a counterproductive effect. Now consider the gagging order. So what a gagging order is, when a book is not allowed or stopped, it's called a gagging order. So gagging of films or books or other form of publication in the interest of decency or morality have ended up generating more publicity and curiosity than they would have ordinarily. For instance, Lady Chatterley's Lover, which is reported to have sold 3 million copies in the UK post the prosecution in 1961. Same likewise with Padmavati, though it had nothing to do with decency and morality, but same ways. When it is tried to suppress a publication, a media art, what it does, it impulses our curiosity to know what is there. So that's how it works out. Also, society must lean in favor of free speech and expression, and the courts must be very cautious while holding or upholding the reasonable restrictions on grounds of notions such as decency or morality. Because well, we should understand these are reasonable restrictions and not just restrictions. Also, if you only consider about being very irrational or vulnerable while looking into any kind of media forms, you judge it irrationally, then it wouldn't be wrong to say that it's just like a Frenchman sees a woman's leg in everything and it cannot be helped. So we need to uphold the creative freedom, the artistic freedom, because even their work is to bring a story in a creative manner. Any kind of book or painting, there's much more to it. That's all. Any questions?
Yeah, so fascinating session, Shreya. So before going on to the questions, just a quick comment. So like me being like myself a student of media law, it's really amazing when you can connect the advances, when you can connect the developments in media law to law in general or other branches of law, so to speak. Like for example, if we have a look at your presentation, you talked about the Heckling test and then the likely audience test, and slowly and gradually you end up judging some work through the parameter of a common man or a reasonable man, right? So uh, it's amazing that it's so similar to the evidences which are required to prove something when it comes to criminal law or civil law, as far as the Evidence Act is concerned. It's just a vague
Yes.
comparison, in the sense that when you talk about the Hicklin test, you are adopting the criminal law standards of beyond reasonable doubt. So it has to be absolutely certain. Even if one person is having some trouble with it, you're gone. Basically, you cannot get your work published. As far as the later developments, you see that the likely audience test, there you are more adhering to the civil law evidence, that preponderance of probabilities, whereby if it is kind of okay, if there is a possibility, go ahead, green signal, otherwise no, it's a red signal. So it's like you never know that when these judges
Connected.
at the time of sitting or adjudicating the Hicklin test or the likely audience test in the Indian context, the Ranjit Udeshi case, etc., it must have struck their mind, probably, these sort of things, directly or indirectly. You just wonder about it.
Of course, of course. And it's a very good note to connect the dots with other angles of law, like civil law, criminal law. Well, it's that's what.
Yeah. So, any students, any questions? Nimita, Sri Soumya, Simran, Sanalika.
Or any clarification on any point?
Ma'am,
Yes, please.
ma'am, you mentioned about the various tests that are being conducted right now, ranging from Hecklin's test to a lot many more tests. So, in the current scenario,
Yes.
which of these tests is the most widely preferred case all over the world? Not only in India, but all over the world. Is there any particular case?
Uh, there's no such parameters as I just mentioned. However, in most places, you know, just like I mentioned about how it's seen in India, well, as compared to other places, it's not the same, because now just I mentioned about Lady Chatterley's Lover. Though it was banned in India, it's allowed in UK. So there's no such strict or we can say definite kind of test which is allowed all over the world. But judges in India, they do look into the contemporary and national standards. They also look into the aversion. They cannot basically stick to one single test while making a judgment, because there is like, practically speaking, if you are the lawyer and your client had some objection with a film, you would definitely try to insist or convince the judge on considering other aspects of the test. So you would tell them, in case if your client has a film which has some obscene material, you would push it to look at the literary merit of the film over the obscene element in the film. So that's what happens. So there's no such strict standards, and I personally believe that there shouldn't be one, because then the scope and the artistic freedom would be upheld to a greater extent. Also, if you have noticed, the Cinematograph Act has been recently amended. So once that becomes, it's just they have just formulated some new rules. It's yet to become a law. So once it becomes law, it would be even more difficult for upholding the artistic freedom, because they say the center would be interfering in how to determine a film. Also, the FCAT, that is Film Certification Appellate Tribunal, has been removed this April. So there are a lot of changes which are coming up. So once this falls into law, it would be even more difficult to understand, and therefore it's keeping that in view, it's important that we consider all of this tests and not just one.
Okay, ma'am. Thank you.
Any other questions?
Am I audible?
Yeah.
Yes.
Ma'am, I believe like there is no standard
No.
line to define what is going, like what should be presented to media. If we take these tests, these are used in different countries accordingly. Like something is allowed in some country and something is not. And as you just talked about the new amendment which is happening in the censorship and all, which will also occupy the OTT platforms, right? I believe they are snatching away the free.
No, sorry to interrupt, but the OTT platforms are not governed by the Cinematograph Act. Cinematograph Act is only till films which are projected in theaters. So OTT platforms are self-regulated.
But there have been a
Please
talk.
continue.
There has been a talk since like few months that OTT platforms will also have the censorship things. So, if won't it
Yes,
be just snatching away their rights? Like, what should be like artistic rights? I believe they are supposed to present what they have in their brains, and that is like taken away from them. Why? Like, is there? Why don't people assume that it is okay to present these sexual contents? It's okay. Like, kids won't be reading it till the age they get like mature and all, and if they consume these things, their parents are supposed to be the person who guides them. Like sex is a taboo in India, and parents literally don't talk about it. So kids obviously get the things from the pornography or the magazines or the books. So I feel it's okay to
that's
produce these
right.
kind of things.
So even I'm of the same opinion, also because I'm working with a production house. So I see, it's very difficult to stop it, because the creative rights of the artist are being curtailed in such manner. Though the CBFC has certain kind of cuss words which cannot be allowed on screen, so such parameters are okay. But the cuts, as you mentioned about on the OTT platforms, yes, this will hinder their right to free expression on screen, or yeah, any kind of OTT platforms as well. So let's see how the law works out. It's still not regulated, so it's still on question. It's been challenged, so let's see how it works out.
Okay, ma'am.
Any other questions?
Ma'am,
Yes,
Yeah, go
please.
ahead, Sri Samya.
am I audible?
Yes, you're audible.
Ma'am, I have a very simple question. Like, up to what extent
Yes.
can you curtail the can you curtail the rights of the freedom of such artists who want to like show what actually they want to show? Because the situation right now.
Well,
Oh, sorry.
mhm. Yes, please go on. The
Yeah,
situation right now.
complete, Sri Samya.
Because the situation right now is
Okay.
OTT, even as she mentioned, the situation is like it's taking its toll on the OTT platforms as well. So how, up to what extent
Yes.
this curtailship being correct?
Well, so speaking about OTT platforms, it was a two-tier mechanism till now that self-regulation will be coming in and they would make the changes. Now they are suggesting a three-tier mechanism. Also on cinematograph, until now we had three kind of certification, that is U, that is universal, UA, that under the supervision of an adult, and A, that is adults. But now they have suggested for under 16 and under 13 as well. So these are not yet to become law. So once it becomes law, I really feel that um, creative freedom would be curtailed up to a great extent, because already it happens that a lot of things people want to show, such as the oh, recent Tandav, which is on Amazon Prime. There were several cuts made to it, and it says that the story has been distorted to a great extent. So going by that, it would be really difficult to uphold creative freedom. However, a rest lies upon how the laws are framed in the coming years.
Ma'am, but what, up to what extent are these laws being upheld? Like on the name of society being like the society's views and perspectives, are these laws doing any justice?
Well, see, I cannot be commenting on the law because laws are made by lawmakers, and yeah, they are on place, but it's the work of the judiciary, and judiciary has been trying to uphold the rights of the creative freedom as much as possible. Like I mentioned about the Full and Devi case, though it came under indecency under the Indian Constitution as well as the Cinematograph Act, even then the Supreme Court looked beyond it, the purpose of the film. So there are several instances like that where Supreme Court or any such court is trying to uphold this creative freedom. However, the laws are being framed, no doubt, but it's at the ultimate thing is the Supreme Court making the judgment whether or not a film should be allowed or disallowed. And maybe we will have films with several kind of cuts like Urta Punjab or several other films you might know, where in the interest of decency and morality there are several cuts made.
Just to
But then again, there is no strict parameters laid down, like you want up to what extent this cannot be said. It depends upon case to case factor, it depends upon judge to judge, and at the end of the day it lies in the hands of the judge. There is no fixed standard as to what extent.
Mhm.
So, as far as this entire regulation of the censor board or the central board for film certification goes, uh, its its primary like it owes its statutory origins to the Cinematograph Act 1952, and its primary
Yes.
function is essentially to certify the movies, right? Whereby it
Yes.
is laying down the certificates, or whether it is of A certificate, UA, US, or X, etc., etc. So, society
Yeah,
at
and they
large
can also
also,
prohibit.
yeah, and
Hmm.
the society at large has somehow got a false notion that to censor basically means to stop something or to prevent something. Censor basically means to examine something and then take an objective decision based on whatever are the norms of, let's say, the laws of the land or whatever it is. And taking a cue on this, misinformed notion, you sometimes feel that even the censor board acts in an ultra virus manner, so to speak, whereby it starts putting up cuts on various film scenes. Its essential role is to certify the films that what age category who can watch. Simple as that. I am skeptical about the fact that it has got the statutory power to actually carry out cuts, what cuts they would be, how many minutes have to be cut, what scene has to be cut, etc., etc. Those are a bit too much, uh, too big technicalities for the censor board to look at. So
Yeah.
that's perhaps one thing which may be looked at.
Yeah, of course. And I think the Supreme Court, even when the Lipstick Under My Burqa was released, even before that, when they suggested for some kind of cuts, the Supreme Court mentioned that it's not the duty of the CBFC to, sorry, yeah, to their purpose is only to provide a certificate or prohibit a certificate, but they cannot suggest for any kind of cuts. So this was even mentioned by the Supreme Court during the matter of Lipstick Under My Burqa.
Yeah, like if the censor board goes overboard on this, then probably the film editors would remain unemployed because they carry out most of the editing because of that. Anything else?
Yes,
Anyone? Any
that's right.
questions? All right, so I think we are almost there at the end of the session. So, Shreya, thank you so much for such an exciting session, for staying true to the topic and getting into the details of it with respect to various tests laid down as well, the contemporary standards, etc. And you took the example of certain contemporary movies as well. So I'm sure all our viewers would be able to connect to it a lot better. So thank you so much for taking out the time for explaining it in such a wonderful way. Thanks a lot.
Thank you, and thank you for having me here, and thank you everyone for attending this session.
All right, thank you.